Hi guys, I'm here with Kevin Sunn, board certified estate planning attorney, background in accounting. We're here to talk about wills, trusts, all that good stuff. Being a lawyer, all the crazy probate stories you've heard, without obviously breaching confidentiality. I think the first question people always ask is, "Do I really need a will, Kevin? I don't really have anything."
I think everybody needs a will,
Okay.
or you're either going to have a will-based plan or a trust-based plan. But it's so important. I always tell clients that everybody has an estate plan. It just wasn't written by you. It's written by the state of Texas. It's in the probate code, and it says who gets your property upon death, when they get it, how they get it, and who's going to be in charge and everything else. So it's important to have a will just so you have your choices in place.
Okay. So I'm gonna keep being the pundit here, right? I'm not going to spend some money on some fancy will. I'm just going to do a holographic will where I write it down and it is what it is.
If it's wholly in your handwriting signed by you, you might be okay, but I've never seen a good one. Whether it's that or even if it's not drafted by an attorney, you have stuff that you can get online or on a shelf. And usually they always have problems that need to be rectified in probate. Usually we can get through it, but it's usually you're going to end up paying a lot more in the end just because of the mistakes and things that are in there that are not compliant with Texas law usually.
So give us some dead giveaways where everybody needs a professional attorney. So let's just be on, or somebody, an attorney-based person or some type of document that's been drafted by someone that's professional, right? But what are some dead giveaways that you would be absolutely crazy not to have someone drafted for you instead of just doing a little handwritten thing?
Anytime you have minor children, for sure. Because without it, they're going to receive whatever you leave them at 18. They may get it, but they receive it at 18, and it's going to be in a guardianship until then, which is very expensive to do. With the will, we can create trust that can extend it to where instead of 18, we can postpone it until 30 or 35 or something where they have free reign of their trust. It's still their assets. We're just going to have a trustee, somebody that a friend, colleague, or somebody that we trust to manage it for them, make sure all their needs are taken care of in the meantime. But that probably the number one thing is for minor children.
Okay. Awesome. I've always heard the number two outside of the minor children in blended family. Absolutely a more critical need.
And that's just an extension to it, but absolutely, because if you look at how the property goes in a blended family situation, it's usually not the way you anticipate. And it usually does not match what we end up doing in the will. And you can very easily disinherit somebody. For instance, if you leave it all to your wife and their stepchildren, well, if you leave it outright to her and she turns around in her will later when you pass and leaves it to her kids or her side of the family or him, then you are essentially disinheriting the kid. So it's so important, especially in that, not to try and do it yourself, to get with an estate planning attorney to make sure that everything goes as it should. And there's different ways we design it. And there's times where we do things outside of the will, maybe a life insurance policy where we leave an amount for the kids outside the will or to the spouse or vice versa, however you want to do it. But so important. You are correct.
Okay. So then we're going to pivot to something a little more fun. Give me, without obviously exposing the names and such, the most interesting or wild probate story you've ever heard, because this is what happens when you get down without a will type of situation, right? You get a lot of these like off the wall situations.
Well, to be honest, in over 25 years of practice, I really don't have so much of an interesting story just because I refer those out. Those are the ones that are going to be contested.
Yeah.
And I stay in my lane. I don't want to go to court even though in probate, we go to court all the time, but it's usually to prove up the will. And when you have a will, and usually 95% of everything is just smooth through probate. But it's the ones that get contested. Those are where the stories are. But it's so common that usually it's the beneficiaries, if there's any animosity between siblings, they're going to fight over the personal property. And usually it's not worth whatever the value of the personal property isn't worth the attorney's time at the end of the day.
Right.
And so we see that so often. I've seen them where they contest a will, and at the end, when it's thrown out, they get the same amount. And again, it just goes back to, well, I'd rather give it to somebody else than give it to you, or give it to the attorney instead of you. Because when you contest it, that's essentially what it's going to go. Everybody gets an attorney, and there's only a certain amount of assets of the estate. And you're just saying that, okay, instead of a bigger portion going to the beneficiaries, we're going to slice out a portion for the attorneys on both sides.
Okay. It's always that, that's dad's car and he wanted me to have it type situation, or some estranged cousin or brother or somebody comes out the woodworks, that kind of situation, right?
Right. And I've seen neighbors go next door to get the patio furniture, everything. For some reason, they think they're entitled to it if somebody has passed. So you hear those things. Usually it is around the personal property. And
Right,
it's usually because of past relationships that never rear their head until mom and dad are gone. That's whenever the siblings fight.
Right. Okay. Talk to us about, special needs trust. Is that a priority? Do people need to start thinking about that stuff? They have kids with special needs. Your perspective on that.
It is definitely something you need to consider, especially if you're using any kind of government or state assistance. That if you leave an inheritance to a child that may have special needs, then that's going to be counted towards their eligibility. And it may wipe out that government assistance. But if you leave it in a special needs trust, then that's going to be outside that calculation. And you're either going to do the special needs trust as part of the will, where it's never created until you die, and it's only upon my death, if I leave it to a special needs child, that I don't need it while I'm alive. We need it at that time, and it can spring out of the will. There's other times where we might want to make gifts, but not make them ineligible, that we would do it now through a living trust, where we fund it and gift to it now.
There's always this new term thrown around called revocable trust. Not new, but a new, call it, popularity of revocable trust, right? Talk to us about a revocable trust. When does it apply? When does it not apply?
A revocable trust is just another kind of estate plan where you essentially have two foundational estate plans. You either have a will-based plan where you're typically going through probate, or you have a trust-based plan where you use a revocable living trust to hopefully avoid probate if you have everything set up correctly inside the trust, or if it's still in your name, beneficiary designated outside of it. So the idea behind the trust-based plan is if I die and I don't own anything in my name, or everything is beneficiary designated outside of probate, then I can avoid probate. And so it is a way to avoid probate. Not everybody needs it. In Texas, we have a pretty easy probate process when the wills are done correctly. We have a thing called independent administration, which is a little bit of court control, but not a whole lot. But a revocable trust is something that we can avoid it altogether. And it's essentially a list of factors depending on the clients, whether we lean towards a will-based plan or a trust-based plan. And those are typically, if blended family, as you mentioned, we typically lean towards a trust-based plan because a will is much easier to contest than a revocable trust. If you own property outside the state of Texas, then you're going to possibly have multiple probates in each property in each state that you hold real estate. And so to cut down on costs, we tend to lean towards the trust-based plan.
Right. Because it's essentially done for you.
Correct. Right. Correct. It's done in advance.
Done in advance, I'm sorry.
That's correct. It's kind of like prepaid funeral expenses.
Right.
You're taking care of it so the family doesn't have to. It's the same thing. We're taking care of probate now so my family doesn't have to do it later.
I always love to hear your thoughts and then everyone else's thoughts, but a lot of people talk about the testamentary trust. So walk us through testamentary trust inside of a will-based plan, that type of planning. What does it do? Why would you use it instead of a true revocable trust? That kind of stuff.
Great question. And there are many different kinds of trust. So I'll get people calling up and say, I need a trust. And I have to say, okay, what are you trying to do? What's your objective?
We're talking about slats, we're talking about cruts,
Islands.
yeah, you can.
Asset protection. There's so many different ones. And then you got not just the legal community, but you have the financial community where they take the legal trust that's titled one name and they want to put a marketing spin on it and call it something else. And so I'll have people call up and say, hey, do you do this kind of trust? And by the time I ask about how it's set up, what they're trying to do, I figure out what it is.
Right.
But a testamentary trust is simply something that is only created upon your death. So the will is the perfect example. Your will is never effective until you pass. And so once you go through probate, the trust is created on the back end, usually to be funded for your beneficiaries to receive it, versus a living trust, or what we call an inter vivos trust. That is something you create now. Right. So that's, like you mentioned, the slat, the islet to hold life insurance to keep it out of your estate, asset protection trust, gifting trust for the kids. Those are all created now because we're funding it now with something.
Obviously, a hot topic every 4 years or so, the estate tax exemption. Talk to us of where we're at with that from a legal perspective and what's on tap for that.
Sure. So we finally have it permanent. From since 2000, we always had this estate tax credit that kept going up, and it would reset every 8 to 10 years back to where it was before. And it's just the way that it's passed through legislation. But currently, the estate tax credit is $15 million per individual, right, which simply means that if you die with $15 million or less in your estate, you don't have to pay the estate tax, which is usually around 40%. If you're a married couple, essentially the first 30 million can be outside of your taxable estate. Right. Everything above that is going to be hit with the estate tax. Back whenever I first started practicing, it was 600,000. Everybody had an estate tax issue. But as it's grown, it's less and less, and maybe 1% of the population even needs to worry about the estate tax right now. But as you mentioned, every 4 years, because it is political, and it doesn't matter where you stand politically, Democrat or Republican, it is always followed along party lines. That typically the Republicans have always wanted to eliminate the estate tax credit, and the Democrats have always wanted to lower it or increase the estate tax. And for different reasons. But usually you never have permanent tax legislation or changes to the estate tax or even the income tax whenever you have a Democrat and Republican mix. Okay. And so you have to have one party in charge of the presidency, the House, and the Senate. That's when you have meaningful tax legislation change. So I wouldn't anticipate that it will go down unless the Democrats were able to get the House, the Senate, and the presidency.
So then the next kind of conversation that is always interesting is single parents of divorced children. Obviously a very common topic. When you think about single parents and their need for an estate plan, walk me through your thought process when someone walks in and maybe they're divorced and they've got kids.
And here's another one. They're in the process of getting a divorce. And I'll have it where they go, well, I'm getting divorced. Whenever I get done with that, I will come to you and update your estate plan. And the problem with that is you're still married. And so if you don't have a will, it's going to the spouse, especially if the children are of the same marriage. And that's not what they want, typically. They want to leave it to their children. They want to have a trustee manage it for them. But a single parent planning is no different than a married couple. It's the same type of documents that we're going to prepare for them. But instead it's the individual. But usually it gets back to the minor children, making sure there's trust involved, and making sure that you have all your assets set up correctly. Part of estate planning is, I'll see it where an estate planning attorney will create all their documents, create a will, but they never get around to updating beneficiary designations, which are so important because if it's not coordinated with your will to get into the trust for the beneficiaries, it could stay out of that trust altogether. And so it's so important to coordinate all that. But again, I think it's the same as a married couple. It's just based on circumstances. It's just we're no longer leaving it to a spouse.
So if I'm getting a divorce, let's say I already have one, and I want to update that plan prior to even getting divorced, especially if it's a 2, 3, longer battle, right?
Correct.
Especially if there's substantial assets involved. And then when you think about minor children and trustees, I personally am an advocate of corporate trustees. That's just my opinion, right? But love to hear your legal thoughts on that.
The corporate trustee side, usually it's a balance. If the client has somebody in their life that they trust, that they know they can manage it correctly, then it's okay to have an individual trustee, usually because it saves money to the estate, because the corporate trustees are going to be higher than, let's say, a financial advisor. And it's just because there's more responsibility of fiduciaries, things like responsibility, things like that. And so there are times where you can have an individual be the trustee, but you have to be careful, because think of you name your brother, and his nieces and nephews are coming in, they saying, Uncle so and so, I need money for this. And you're either going to have somebody who's going to say, well, whatever you need, right? And spoil them like they should, probably, right? Or they're going to be the opposite, where they're just not going to they're going to hold it back, right? And so one thing they're not going to do is read the will or the trust every time they got to make a distribution.
Probably not.
But a corporate trustee does.
Right.
And that's where we lean towards it, that it usually there'll be one, certainly married couple, spouse will continue to manage it. They're still familiar with that financial advisor. And so that's a good fit. But beyond that, I do like corporate trustees. In my own planning, besides my spouse, I have my sister first. And then after that, I have corporate trustees. And I have plenty of other options, but it's usually a better option doing that.
I do love that idea too, that contingent or the alternate trustee is a corporate trustee, right? Because maybe there's one person in your life you trust, right? Maybe it's your brother, who's the smart guy, who's got the right hand on the shoulder, understands finance and managing money, that kind of stuff. That's great. Then probably beyond that, maybe you have nobody else.
That's right.
Right? And then you go, okay, well, maybe I leave it up to chance, or should I go to a corporate trustee? So I like the corporate trustee. I think not a lot of people really kind of focus on that or that type of situation.
And a lot of times the corporate trustee is going to end up doing better, even though they may have more expenses. They're going to manage it better, typically.
Yeah.
And so at the end, they're probably going to make more money than your sibling would.
Right.
And so it's very helpful for that. The other thing I like to do, even if they don't name a corporate trustee, I like giving my beneficiaries of their trust, like my own kids, that at 35, I have it where they can manage their own trust, do what they want with it. But at 25, I allow them to remove an individual or whoever the existing trustee is, but only to name another corporate trustee, not to name another individual because they're just going to name their best friend, but to name a corporate trustee so they can look at it and say, hey, they're not performing so well. Right. So I think I'm going to go look at different companies that can manage it better.
I could agree with that. When you go down this rabbit hole, right, the other questions people ask is the easy one, but I'd like to put it on record. I'm getting a divorce, and I've already got my estate plan the way I want it. What happens?
So, well, whenever you get a divorce, it's no longer going to be the estate plan you want, because we got to remove the spouse. Right. And typically there is a law that says once you get a divorce, then your spouse is treated as predeceased. So if you don't get around to updating your will, then it's okay. I wouldn't rely on it. And there is one particular asset, which is a 401k or any kind of ERISA plan, that they don't go by that law, that it will go to a divorced spouse unless you update it. But it's so important to update it. Again, like I said, whenever you know that you're going through that, to leave it to your kids, because up until that date of divorce, it's going to go to them by default. Or again, if you don't update your will, that typically you will have the spouse as your primary beneficiary.
So definitely, once you get divorced, you got to update it. Not a extreme an emergency, but something you got to get done. Yes, no.
I would say extreme emergency. I mean, if you're divorcing, I mean, chances, yeah, I mean, I see what you're saying because of the alternate rule that basically says, all right, it's, they're treated as predeceasing. It's not going to go to them. I wouldn't rely on it. It's just more to prove up whenever you go to probate. It's kind of like the will in a box or off the shelf, that there's all kinds of problems that you got to fix in probate. That is just things that we don't want to mess with.
Right, right. So then the other one that people always talk about is, man, what happens to my business? Right. So I think the hard to figure out asset is what happens to my business.
All depends on the type of business, right? And it depends on your clientele. It depends on your assets. Is there any other family members running on it? Is it a solo business? Is there partners?
Right.
So there's many different variations, but as you point out, it's so important to have something in writing. I typically tell my business owners, write down a business succession plan. How do we continue to pay payroll over the next month or so until we go to probate? But think of all the things that if I'm not here, how will this business continue on? At least enough for us to sell it or pass it on through our will. But it's so important. Like, for instance, on mine with the law practice, it's not that there's going to be a sale of my practice. I'm a solo practitioner. My clients are just going to go elsewhere at that point. But I do have a business succession planning that, with letters, that my assistants will stay on long enough to get everything out, all original wills returned to clients, but also have recommendations of where they can go. This is the probate attorney I recommend, the estate planning attorney, the business attorney, etc. But it's so important, as you mentioned, but again, it just depends on the business.
Right.
If there's a sale of a business, that gets a lot more complicated, but it's at the end, it's going to be the executor controlling that. And sometimes it's as simple as them retaining a broker, no different than if you're trying to sell your business now, that we do that upon probate. I tell clients, think of, if you're gone, that maybe competitors. Give me a list of people to call that might be interested in that business. If you're in a partnership, it's a little bit easier because we typically will do a buy-sell agreement where each of them agree to buy the other one out if there's a death in the family or an incapacity or something like that. So again, there's different variations, but it is something to look at for sure.
I think if you treat the will almost like a beneficiary designation for your business, it's probably or trust, whatever, one of the two, right? It's a beneficiary designation. Brings me to the most probably important part. Beneficiary designations supersede all.
Right.
I've heard that since the day I was a financial advisor, and I wanted to get your take on that and why that is.
It's because there's a contract between you and whatever that institution is.
Right.
That trumps everything else. And so if you have a primary beneficiary, contingent beneficiary, it's laid out, it will go to them and it goes outside of probate. But if you fail to do your beneficiary designations, or maybe the people you had have already predeceased you, then the default is usually always the estate, which means you're back in probate. And so, which may not be a bad thing if we're going through probate anyways, and we need to get the funds into the trust for the kids. We eventually want it tied into that. But retirement for instance, is something that we always keep outside of, that is kept in our individual name with beneficiary designated to spouses or kids, and it has to coordinate with that. But even with spouses, we typically just name them outright because of the spousal rollover rules and the changes that have occurred. But the main thing is, it's so important to make sure that all your beneficiary designations are properly coordinated with your will or your trust-based plan.
And I mean, obviously, not as common today, but imagine if you were working at a job 20, 30 years, you divorced your ex-husband or ex-wife 5 years ago, you pass on, you didn't change your beneficiary. Kevin, who gets the money?
Depends, right? Um, Based on state law in Texas, that is an asset that the spouse will be treated as predeceasing. So it will be part of that business owner's estate and it would go through their will. So if it's listed as the kids, even in trust, that's who it's going to flow through.
What if it's listed as the ex-spouse on your beneficiary and your 401k?
401k, again, that's ERISA. So that one's very important. That one will go to the ex-spouse.
Okay.
But business interests are controlled by state laws. So
Right.
we're still under that rule. It's not as bad, but it's just you have to coordinate all this stuff.
What I'm really going after is probably the guys and gals that worked at a job for 20, 30 years in their 401k. Right. And they divorced their ex-wife 5 years ago. And every single year they just click the yes box on their 401k, yes box on insurance, and move on with their lives.
Right.
When that 401k is definitely going to.
It's going to the spouse by federal law.
The ex-spouse.
The ex-spouse by federal law.
Right. No wiggle room, no.
You have to look at the divorce decree. There may be a quadro in place or something like that.
No quadro in place.
But no quadro in place. That's going to be the default.
Okay.
It goes to there.
Okay.
IRAs, which are controlled by state law, those will still be applied. You still apply the state.
Okay.
But it's going to be those ERISA plans,
Yeah.
money purchase plans, defined contribution plans, if there's a death benefit, things like that.
Okay. All right. And I love to make that point to people because we're like, I haven't looked at my beneficiaries in a decade. I'm like, didn't you get a divorce 5 years ago?
Right. So, and keep a copy of beneficiary designations. I always tell clients, keep a copy of your beneficiary designations with your will. Hard copy. Just make sure they're not lost.
Okay.
Just seen it happen a few times, and it's usually a bad result.
Yeah. So because companies do make mistakes.
That's right.
They do forget to process stuff. They
lose them in transition, maybe change softwares or who knows.
Change companies.
That's right.
Change 401k providers. All important stuff to think about, actually. So it gives me to think about my own plan, actually. Guardians. This right here, I think, is the one that makes people stop in their tracks and go, we're not going to finish the will. Yeah. Right? Mm-hmm. You get that probably a lot. Husband and wife walks in, start up, we should get a will. And then we get down to who's going to be the guardian of our children. And then they go, we're going to think about it. And then 6 months, 6 years, 12 years, right? Can't agree. Give us some advice there, what to do, what to say.
It happens so many times. And I'll have clients that come in. I tell them it's better if we have the same people, of course. Especially if we die in a common accident. But at the end of the day, what's important is not to delay, because they procrastinate or they delay because they can't agree, and they'll get around to it once they agree on it. But okay, they probably won't. And what's important,
ebbs and flows in that conversation.
That's right. But what's important is I just tell the client, you pick your guardians, she'll pick her guardians. And at the end of the day, the court has 2 good sets of primary guardians to choose from if y'all pass at the same time. At the end of the day, whoever goes first automatically goes to the surviving spouse, and their guardianship documents are going to control who it goes to. It's only an event where there's a common accident. Now the court has 2 sets of guardians that they can pick at that time. But what's important is just to have it in place. You're way better off to do that because, as I said right from the beginning, everybody has an estate plan.
Right.
So the state has told us who's going to be the guardian of your children, which is going to be your parents, grandparents, up the family tree until you run out of room there. And then you go to siblings and other next of kin. And you have family on both sides. So you have competing interests. So if, for instance, you have friends that you want to name, maybe parents or siblings are out of the country and you want to keep it more local or close to their friends and not disrupt their life as much if something happens, especially when our kids are in their high school years, where if you think about, they lost their parents and now they lose all their friends at the same time.
And so it is. And so it's just so important to have a guardianship, because whoever you list on both spouses, first, second, third, they're going to go to the front of the line. And that's who the court will usually appoint. They don't have to. The court will still act in the best interest of the child, but they highly, highly consider it. And typically that's who the guardian will be.
Okay. All right. So I got to ask you, I'm sure there's lots of people are procrastinating, because I do this on a regular basis. What's the one thing you tell them to stop procrastinating on getting their wills done?
Well, everything. Just don't procrastinate. Get it done. It's so important. Do you mean more like what their situation is? That, okay, these absolutely need.
We'll start with that.
Okay. Again, it falls back to everybody, right?
Everybody.
It's even, I had going back to a story where one of the worst probates I've ever had is, it was a individual that had a child, and up above is one parent. It was just single parents all the way up and all the way down. And so they didn't do a will, and the person predeceased, they had no descendants, which meant it goes back up to the family tree. At one generation, now they had 12 kids, and they had a bunch of kids. So their estate ended up going to all these multiple people, that heirs that they probably never met, didn't know them from anybody else. If they just had a will and just named a charity, it would have been an easy probate. Instead, it was a genealogy chart that I could roll across my whole conference room table, our old conference room table. It went from one end to the other, and they were getting one of 1,000s, and it wasn't a large estate. And so that person, I'm sure, thought, well, I don't have anything to leave or anybody to leave it to. And that was one of the most difficult probates. But I get back to, what I tell clients a lot is, on my own experience, is I didn't have my estate planning done until my first daughter was born. And then 2 days later, we're signing documents, just because it is so important whenever we do have kids that you got to get it done.
So the other one is probably major adult children, right? Someone passes without a will. The adult children, technically, by state definition, have claim to half of the assets. Fair? That are outside of the, in the probate scope, right?
If a
bank account or brokerage account,
married couple, adult children, or more of a blended family.
Married couple, adult children.
Yeah. If it is the children of the same marriage,
right,
and it's community property, it all goes to the surviving spouse. Nothing goes to the children. That's by intestacy how it goes. But if it's a blended family, you got to look at the tables. It's typically 50% goes of the community property goes to the spouse. The other 50% goes to the adult children,
right,
of that marriage, or of outside the marriage, or of the marriage. It's whoever died, it's all of their children,
right,
and they would receive that amount. And a lot of times the couple may go, I want to provide for my spouse. I want to leave something to my adult children, or not. And so I see all kinds of different circumstances, and it may be, okay, let's just do it in a life insurance policy. Let's do it through a POD or beneficiary designation or something like that, where it goes to them outside of it. But at the end of the day, it's just whatever the client's wishes are. And it doesn't matter the circumstances. You can't procrastinate on doing any of your estate planning. It's not just your will. It's your power of attorney, it's your medical power of attorney, statutory durable power of attorney, directed physician. These are all documents that are important. Your statutory power of attorney, which is who's going to help pay bills, right? If I'm unable to. So important, just to keep us out of a very expensive guardianship. Probate can be expensive. Guardianship is very expensive, and you want to avoid it at all costs.
One last thing for the folks going to college, kids going to college. Medical power of attorney for said minor children, now major or adult children. Thought process on that.
You still have, again, the default rules, which is typically the parents, unless they marry. They will still have medical decisions, but it's so much easier to have those kids have a medical power of attorney that the parents can show, where they don't have any issues if there's a medical emergency. I've also seen it where instead of a medical power of attorney, they won't share information with the parents. And rightfully so, because of HIPAA laws,
Of course.
that your medical power of attorney is never effective until you're incapacitated. But then I'll see, parents with their kids, is their kids going, I want my mom to know all this or my dad to know all this so he can help make a decision. Sometimes the hospital or the clinic, they'll provide proxies or something like that, different than the medical power of attorney. But as you point out, it's so important to have the medical power of attorney. Your financial, usually, college kids, they have a bank account.
Right.
Put a POD on it. Put a POD back to the parents. It's usually not all that much unless it's significant. Then start doing your estate planning. Not to take away from it. It's just with kids, is that if they're not married, don't have kids yet, usually giving it back to mom, and it was mom and dad's money to begin with.
Right.
So it's just a way to direct it, but it is important.
Awesome. Okay. Well, cool. Well, Kevin, thanks so much for hanging out with us. Learn lots of new stuff. I'm sure people are listening and learn lots of new stuff, so we appreciate you.
Of course.
Awesome.
Thank you for having me. I appreciate it.